taking the financial
It's actually a very interesting issue. It's actually a very
Okay, I'm going to start. You can keep getting your food. Just a quick housekeeping thing before we begin. Richard Cleary, our president, just asked me to remind everyone that we have an organizational meeting tomorrow in Big Warren 105, room 105 at 12:10. What?
Wednesday?
Oh, Wednesday. Sorry, yes.
103, Big Warren.
103, what do I know? Fine, so Wednesday, 103, 12:10, 12:10 I'm right about. So everyone's encouraged to come, especially 1Ls if you want to join FedSoc. We'd love to see you there. Great organization, so we hope to see you there Wednesday, 12:10, Big Warren 103. Moving on to today's events, we're honored to have Professor Josh Blackman here, who's going to speak about the constitutional challenge to Obamacare in his recent book. Professor Blackman is an assistant professor of law at South Texas College of Law. He's the founder of both the Harlan Institute and Fantasy SCOTUS, and blogs which are very popular, Josh Blackman as well. He's actually been guest blogging this week at All Conspiracy about his book and these issues. He went to George Mason Law School and he clerked for Judge Kim Gibson and then Judge Danny Boggs. I'm also honored to have Professor David Pozen of Columbia Law School here. He graduated Yale Law School, clerked for Judge Garland, DC Circuit, and then John Paul Stevens at Supreme Court. He was a special assistant to Senator Kennedy on the Senate Judiciary Committee, and then special advisor to U.S. Department of State Legal Advisor Howard Koh, and he just joined the law school last year. Professor Blackman.
Thank you. Thank you very much to the Federal Society in Columbia. Thank you for everyone coming. I see we have a lot of people attending. You've all studied anti-abuse abilities, right? You've all studied this in common law. You all know about the Obamacare case. My goal for today is to tell you something you probably don't know. So let me start with a very broad overview of the case. The Supreme Court, in a somewhat bizarre opinion, upheld the Affordable Care Act. You had the opinion of Chief Justice John Roberts, who said that the Affordable Care Act, which in part requires people to purchase health insurance, is constitutional. Why? Because it should be construed as a law that places a penalty on not having insurance. It's effectively a tax on not having insurance. By that very narrow statement construction, as many of you know, the law was upheld. There was a very vigorous dissent before Justices Scalia, Kennedy, Thomas, and Alito, which said that this law is unconstitutional in its whole. There were some other wrinkles as to what the majority opinion actually held, but that's the stuff we all study in common law, and Professor Pozen will teach you ably. My goal is to teach you how it got there. So the Affordable Care Act was actually passed in March of 2010, but the constitutional challenge was started much earlier. In the fall of 2009, for those of you who are close followers of the blogosphere, there was a lot of rumbling about why this law might have been unconstitutional. Randy Barnett, among others, were very vocal and saying this law was unprecedented. What's the need for a law unprecedented? Never before had Congress passed a law that mandated you to do something. That was the argument. But how did it get there? So this will be actually a little treat for those Federal Society members here. And I encourage all of you to attend any Federal Society meetings because it's a very good group to get involved in these kind of high-profile cases. Roughly 3 years ago, November 2009, at the Federal Society meeting in Washington, a group of libertarian lawyers were just kind of chatting, saying, wait a minute, this law is something off. There's something off about this law. There's something different about this law. And from that fateful meeting involving Randy Barnett, Todd Gaziano, and a few others, they hatched an idea of why this law is different. What was the constitutional argument? In the past, everything that Congress regulated was activity, doing something. This law was different. It was regulating inactivity, and that was the whole. Now, you might think that argument's good or bad, has merit or not, but it had legs. In the words of Professor Jack Balkin, who said, this argument went from off the wall to on the wall. That is, it went from an argument that few people took seriously to something that has broad appeal. Now, why did it gain so much traction? If you study constitutional doctrine, take the Second Amendment, for example, it took nearly 20 years to get the D.C. v. Heller. This case happened in less than a year. What was so prominent about this case? This, I think, is where the intersection of law and politics happened. You had a very strong, growing movement called the Tea Party. Remember back then in 2009, 2010, which rallied around the idea that this federal government was growing way too big, way too fast. And they glommed onto this idea. You had almost every single congressional Republican glob onto this idea that Congress couldn't regulate activity. And when you have these movements come together, it creates kind of what Bruce Ackerman called kind of a constitutional moment, where everything kind of changes the way you look at the Constitution. And in the span of less than a year, a crazy constitutional argument became legitimate. And it went through the courts. The government had mixed victories and defeats in the district court. They had a mixed victories and defeats in the courts of appeals, and they went to the Supreme Court. Now, it was at this point that the politics of the case reached its apogee. You actually had strong movements outside the court to persuade the justices. We have rumors of leaks that the Chief Justice changed his vote. We have rumors that people tried to influence the justices. Many prominent conservatives who heard these leaks wrote in newspapers and op-eds that the Chief Justice should be growing a backbone. I can tell you these weren't just random. They were operating on intelligence that there were leaks. We had the President of the United States telling the court to, quote, exercise its jurisprudence carefully. The President, and I've looked into this doesn't happen a lot, talking about a case after it's been argued for, it's been decided, saying you should do the right thing. And mind you, this was after the President's State of the Union address in 2010, where he criticized the court for his Citizens United opinion. So you have all these political forces coming down the Supreme Court, which makes the change vote of Justice Roberts, if that's indeed what happened, that much more important. How should we understand NFIB? Is it simply a case of law or a case of politics? It's for these reasons I think this case was truly unprecedented in the modern era, that every aspect of our government, the President, the Congress, the states, we had 26 states challenges, all converged in this one law, in this one case. And the fact that it was resolved before the 2012 election let everything maintain the status quo. Going forward, though, there are a number of interesting implications of what this case means. What about Commerce Clause doctrine? Well, there are not going to be many other laws like this. I don't know too many other laws that try to regulate inactivity. But I think it does represent a sign that the Roberts Court is committed to what we call the Federalist Revolution, that they're going to police the bounds of what the federal government can and can't do. I also think it represents a kind of litmus test for the American people of what their tolerance is for intrusion by the federal government. When this was passed in 2009, no one really thought much about it. This had been implemented in Massachusetts and other states, and people didn't really object. But this notion now that people accept, whether you believe it's valid or just partisan, that the government can't force us to do something, I think actually has significance. And in the future, as laws attempt to regulate more aspects of human behavior, I think this will be a lodestar we can look back at when this pivot changed. And also, I think it reflects a lot about what the Roberts Court will do going forward. I wrote this book before the decisions in the Voting Rights Act. I wrote it before the divisions in the DOMA case, about a month. And I think we saw a court that was willing to exercise this muscle, but the Chief Justice pulled back on this case. Dahlia Lithwick had the great quote, Roberts had his hand on the gun and pulled it down. And for those who actually followed in real time the announcement of the opinion, the first 20 minutes of the opinion when as the Chief Justice was reading it, you thought the case was going down. But then he changed it. He said, but now we turn to the taxing power. So this case is a real big bellwether for the Roberts Court. President Obama's got 3 years left, so whatever he did, I think will have short-lasting implications. But what this could have meant for the Roberts Court going longer, say, for example, had the President gone on and attacked the court during the 2012 election, that might have set a very dangerous precedent going forward. And so that's a brief overview. We're very honored to have Professor David Pozen, who actually read the book and is going to be giving some comments and questions. And after that, I want to open up to all of you. I know what I wrote. I want to hear what you think. And hopefully we can have some good discussion.
Thanks. We're lucky to have Professor Blackman here with us. He's a rising star in several areas of public law. I just learned that this is the first stop on a book tour, so you heard it here first.
I got you before NYU. NYU's in the afternoon.
Take note. Glad you appreciate the hierarchy. So I found the book, which I commend to all of you, impressive on a number of levels. It's a pretty remarkable feat of legal reporting. First of all, Particularly unusual was the access you got to the executive branch deliberations on the case. You really get inside the Justice Department's development of legal strategy in litigating the case. That is very rare to have that window into how constitutional law gets worked out. Just the speed with which Professor Blackman got this book out is also, of course, notable. We're only a year and change out from the case, and the major book is already done and published, or about to be published tomorrow. The way in which Professor Blackman makes quite dense material about the many different issues playing around in the case accessible, and the kind of fair-mindedness with which he presents material, I also thought were exemplary. So really a great book. It's a fascinating story, more fascinating than I even realized. I followed the case pretty closely in Professor Blackman's telling. There are a number of things that were new to me in the narrative, even though I thought I knew the case pretty well. The way, for example, that Congress ginned up constitutional findings about whether the law was or was not constitutional so late in the legislative process, almost as an afterthought, was something I hadn't appreciated. The drama surrounding which lawyers would be selected to represent the challengers was also pretty enjoyable. I think you referred to it as a beauty pageant of lawyers.
The beauty contest where they all come and pitch and they do swimsuit competition, town competition to see which one will be hired.
So this may await you and your futures. The way that the Solicitor General who ended up arguing the case before the Supreme Court was a graduate of Columbia Law School named Verrilli. He's still at SG. The way in which he shut out academic advisors into the way the case would be handled, although painful to hear as an academic, was interesting. I had not realized also that the previous SG, who was serving in the acting capacity, had apparently solicited quite a bit of academic input into how the case would be argued. And then the drama kind of within the White House about how the president would be told what the outcome of the case was on the decision day was also pretty funny, given that the initial reports, you may remember, from CNN and Fox News had it wrong. It said that the mandate had been struck down. They clearly jumped the gun reading only the first few pages of the opinion. And if you want really breathtaking legal thriller stuff, the chapter on that announcement day of the opinion is particularly riveting. I knew the outcome of the case, and I still kind of have found it hard. I'm going to just pose a few questions to Professor Blackman and then turn it over to everyone. But I wanted to start where you started, about the kind of dizzying speed with which an argument that seemed to be off the wall, to use Professor Balkan's terminology, became on the wall within con law. So one thing that was disconcerting or kind of jarring to a lot of con law scholars and followers about this litigation was that at the time the law was passed, the idea that it could be struck down as exceeding Congress's powers struck many as frivolous. Nancy Pelosi has the famous quote where she was asked about whether the law might be unconstitutional. She said to the reporter, "Are you kidding me or something?" Yeah, like it was a joke. And even most congressional Republicans who opposed Obamacare and voted against it didn't muster constitutional arguments against it. And presumably, if they were looking to take down this law, prevent it from being enacted, they would have wanted to use any arrow in the quiver, particularly such a decisive, potentially decisive arrow. Only very late in the legislative process did any members of Congress even start to make constitutional noises. So I think it's safe to say that circa 2008-9, this seemed like a pretty solidly constitutional measure, whether you thought it was good or terrible policy. But then, within a period of 2 to 3 years, this out there argument gets normalized to the point where it almost strikes down the president's major, the centerpiece of his legislative agenda. So I guess I wanted to just hear a little more from you about what you think this tells us about the way con law is practiced today in America generally. You cited the Tea Party as a significant influence on this matter, but are there any kind of more general lessons about the way in which politics have gotten wrapped up in constitutional law, the way in which the polarization of the parties makes con law more volatile, the influence of of modern media, the current court susceptibility to what seemed like fringe arguments. I mean, anywhere you want to go with it, but what do you mean? The speed of off the wall to on the wall just struck me as a rich theme.
Thank you. That was probably one of the best reviews I've gotten. Here's my plug. I'm actually selling the book out there. I'll be autographing later. The book comes out tomorrow, so you're actually one of the first people to ever be able to buy it. You're right. The Constitution and the laws have gotten very closely intermingled. For many years, when we had this idea of a living Constitution, it was viewed that more or less that laws are politics. I mean, that was what many people believe. We're all realists now. But I think in the last 20 years, conservatives took very strong efforts to associate themselves with originalism, this idea that we need to enforce a constitution as originally understood. And that proved pretty effective. Look at a case like Heller. But this case represents the exact opposite. This was a case of what I call libertarian popular constitutionalism. It's looking to what the people think to inform the Constitution. Randy Barnett, who's been a mentor to me, was a genius at this. His goal was not only to make a constitutional argument, his goal was to make a movement. By his writings, by his utterances, I think Jack Balkin had a great post on this, by his very act of spreading this message of the Constitution and people listening to it and hearing it and saying, yeah, that makes sense, the Constitution can't force me to do anything. Backed up by this activity-inactivity distinction, it made something that had legs. And there was one very poignant point, where, by the way, Jack Balkin's professor at Yale, Randy Barnett's professor at Georgetown, they're very good friends. At one point, after the judge in Florida ruled in favor of the challengers, Balkin emailed Barnett and said, your idea has gone from off the wall to on the wall. Now that a judge is willing to accept an argument that, as Professor Pozen said, was frivolous. I mean, I myself thought this argument was silly when I first heard it. But then after a while, I'm like, yeah, that kind of makes sense. The speed, though, is even more fascinating because there was a sense of urgency. These ideas were cooked up, I'm not kidding you, in about a month. The Federal Society meeting I mentioned happened around November 19, 2009. About 3 weeks later, the Heritage Foundation released this 20-page report, which Barnett co-authored. That report was then immediately run across the street to Capitol Hill. They had a private briefing where they briefed all the members of the Senate on this. Then all the members of the Senate read it. Senator Orrin Hatch read it into the congressional record. Because of this urgency, it went from a conversation to a white paper to the congressional record like in 4 weeks. And it was needed because the president had made intent that he was going to pass this law. Professor Pozen worked for the late Senator Ted Kennedy. One of the reasons why there was such urgency to pass this law was because of the passing of Senator Kennedy. The election of Scott Brown almost threw an entire wrinkle into the ACA, because Scott Brown was a 41st vote. After Scott Brown was elected, you can no longer have a filibuster. So the Democrats were forced to send a bill that already passed the Senate by a narrow margin to the House. There was no time to fix it up and fix any errors. A lot of the errors we have now are a direct product of the fact that it was never reconciled properly. Because had they sent it back to the Senate, it would have been filibustered. But going forward, I think we're actually seeing on both sides, Republicans and Democrats, using the rhetoric of the Constitution to make points. The president, in particular, if you look at his inaugural address, at the speech he made at MLK at 50, he's very big on using tropes like the Declaration of Independence and the Constitution and notions of protection to try to articulate a positive vision of liberty, the notion that without security of the state, freedom means nothing. And this is very different from what most libertarians say is a negative view of liberty, that the Constitution exists to prevent others from harming each other, and the government stay out of the picture. And at the end of the argument with Verrilli and Paul Clement, there was a very, I think, interesting vignette, which I call Two Conceptions of Liberty, where Don Verrilli said, hey, wait a minute. In order to have freedom, to have liberty, we need to have security. People who don't have insurance and can't pay their bills aren't very free. And then Paul Clement went up there and said, nuh-uh. This is a very funny conception of liberty which requires someone to buy a product. I think this represents two stark visions of how our Constitution works. Clement was going right after Justice Kennedy with his visions of liberty and dignity, whatever. Verrilli, if it's to believe, was going after the Chief Justice. That was his intent. It was this notion that we have to have some sort of respect for the branches, that the government does have this power to enforce certain laws to keep protection. So I think we will see this kind of nexus between law and politics grow more and more. What this means for common law professors is tough, because we like to work in doctrine and think things through and take our time. Meanwhile, a couple of vol conspiracy blog posts and a Heritage white paper are probably the most important constitutional documents of the 21st century. I mean, in a short period of time, Barnett's op-eds in that white paper result in probably the biggest common law case, of the year. And it usually takes years and years and years to develop that. So I guess for site count, we should stop doing law reviews and start doing white papers, which is not a very good, not a very good thing, I don't think.
Yeah, well, it helps
That's
for one's white paper when you have a whole major political party.
And the machine's behind you, yes.
Behind you. Very interesting. Well, maybe let's pick up for a moment on the Solicitor General Verrilli you mentioned. One striking aspect of the book, for those who follow the case, is how celebratory it is of Don Verrilli's performance. That's a congenial take for us here in the room as Columbia folks, given that he went here. But that's not the standard story. The standard story is that the Solicitor General kind of muffled the oral argument. He famously, actually physically had trouble getting out an answer to one of the early tough questions. But you tell this very kind of redemptive story. In a few ways. First, you say that he de-emphasized what was a losing argument by the previous acting Solicitor General, that the limits to congressional power were to be found, if anywhere, in previous Commerce Clause cases, Lopez and Morrison, when the activity that Congress wants to regulate is too attenuated from commerce, or when it addresses a problem that's local in character and not truly national, then the previous Solicitor General would concede that would go beyond the reach of Congress's Commerce Clause power. But Verrilli comes in and scraps that, sees that that wouldn't provide a satisfying limiting principle, and instead pushes the tax power argument, which would ultimately save the day. I guess I wondered whether maybe you were a little too friendly to the Solicitor General. For one thing, the tax power argument was in there previously, and for another, it only got a few pages, right? In the end of the government continued to lead heavily with the Commerce Clause, so maybe the foresight wasn't quite so great to keep it in, and then. It doesn't seem that the Solicitor General saw a number of other things coming, like the way in which the necessary and proper clause would be found to be insufficient by the Supreme Court, combined with the Commerce Clause. So another aspect of the ruling, for those of you who don't already know it well, is the Chief Justice said that this law, in addition to not being sustainable under the Commerce Clause alone, can't be sustained by the Commerce Clause plus the necessary and proper clause, because whether or not it's necessary to effectuating this regulatory scheme is not proper. This will make more sense to anyone else here pretty soon who haven't yet studied common law. And that's kind of nowhere really touched in the Solicitor General's brief, as I recall. So I guess I'm just curious about why really emerges so heroic from the story.
So that's a very good point. Verrilli was hammered. For any of you who remember, the top page of the Drudge Report, I think it was Obama lawyer can't defend Obamacare or something. The RNC put out this nasty ad which basically attacked him, which is probably first. He actually choked, literally. In the weeks before the argument, he had done a total of 6 moots, and he had talked so much his throat was dry. Before he got to the podium, he actually took a sip of water and went down the wrong pipe. After about 30 seconds of talking, he literally couldn't breathe. He was gagging. The guy couldn't breathe. And listen, he choked. And listen to the recording. I think I counted about 6 or 7 seconds of utter silence. And you can hear him reaching for glass and clinking, the ice cubes in the pitcher at the podium. It was embarrassing. So his performance was quite bad. I will fully concede that. He didn't do a very good job. But I think there were a couple points that he made that were quite strategic. So the first question for everyone who follows it is a limiting principle. What's a limiting principle? The broccoli question, right? If Congress can force us to buy insurance, what can't they do? Everyone knew that question was coming. Every law professor in this country wrote 15 articles and op-eds about what the limiting principle was. Any of you for first-year moot court, if you are arguing this case, that's the number one question you have to be ready to answer. What is a limiting principle? Justice Alito asked him, I think almost verbatim, General, tell us succinctly or concisely, what is your limiting principle? That was the question Alito posed to him. He went on a 45-second tangent that kind of seemed to meander and veer everywhere that didn't really give a limiting principle. But wait, if you actually read the SG brief, what he said out loud was almost verbatim, paraphrasing from his brief. In other words, he stuck to his script. He wasn't unprepared. He wasn't just messing it up. He was giving the statement that had been rendered and read by probably hundreds of government lawyers. One aspect that I really learned about this case is the act of writing a government brief is very different than writing a private brief. You've all been summer associates, whatever. You can make any argument that works. When you're writing an SG brief, you're very constrained in what you can say because you have the institutional interest of the United States behind you. You have the president's policies behind you. You have to be very focused. The process of writing those few sentences probably took months. I'm not even being facetious. They thought those sentences through very carefully. So his answer, which wasn't well rehearsed, was meant to be very precise. Now, why did he give such a rambling answer that didn't limit enough? It was a belief of the government that if he actually gave Alito a limiting principle, right, it wouldn't limit enough, and that would be enough to strike it down. You might think that's an arrogant position, but that's what they determined. Why? Because in the lower courts, a number of conservative judges took what had been the Lopez-Morrison limiting principle and said, well, that's not enough. It goes too far. So he didn't want to take that position. But on the second point, which is the taxing power, this is really where the government did change argument. Of course, the taxing power had been argued below. In fact, funny vignette, everyone remembers in 2008 the president said, I will not raise taxes. Everyone remember that? In the early days of the Obamacare litigation, the White House actually said, we don't want you to argue that the taxing power would be a political loss. I'm serious. The government, the White House actually wanted to take the taxing power off the table because it would maybe renege on the president's campaign pledge. Neil Katyal had to actually write a letter as acting SG. Kagan had walled herself off, remember? So Katyal had to actually write a letter saying, hey, White House, we need this argument. We need this arrow in our quiver. And they preserved it. But it's always presented as, is this law a tax? And there's a problem with that. If you actually read the statute, it doesn't say it's a tax. In fact, the legislative history is somewhat ambiguous, but most members of Congress didn't want to be framed as a tax, that'd be unpopular. But what the Solicitor General saw, that this hadn't been briefed before, was a case called New York versus the United States. It's a commandeering case, we'll study it later, but there's one line in particular. It was an O'Connor opinion where she actually said that if a penalty could reasonably be construed as a tax to save it, we should so do. We should do it. O'Connor wrote that. If there's a penalty that we can construe as a tax to save its constitutionality, we should. That case had never cited that proposition before. And that's something that the SG did personally. And that was exactly what John Roberts did in Savings Instruction. If you read the transcript, yes, it's 3 sentences in the briefs, but Verrilli said it himself about 15 times in the argument. He kept bringing it up over and over again. And he did it not on day 2, which was a Commerce Clause day, but day 1, which is the Anti-Injunction Act day. There's a very clear point in the transcript where he actually pivots, says, Your Honor may turn to another point. And he kept saying the most reasonable way of reading it, the most sensible way of reading it, if you have an ability to save it, you should. So even though there was only mention a couple pages in the SG brief, that was all that was needed, because Roberts brought it up himself. He actually asked the guy representing Jones Day, Counselor, if we can read this as a tax, shouldn't we save it? And one of the lawyers in Jones Day told me that if Roberts bought that argument, if he made that inferential leap, it's a very easy road to save it. So while everyone else was talking about the taxing power and the commerce power, the people on the inside knew this was coming. This was a very big issue. That's why I really argued on day 1, because he had to make the representation. It was a very important representation. The only way this works is that the mandate is not actually a mandate. Let me explain. Because if the law actually forces you to buy insurance, what happens if you don't buy it? You go to jail. If you're a felon, you have to report to a parole officer, or you're committing a crime. The Solicitor General had to actually get the representation of the United States government, which was very hard for him to get, that there was no collateral consequences, that there was no actual negative consequences. It was only a penalty that you had to pay. With that representation, which took a lot of effort, there were only a few sentences on this, that was the argument. Now you're right, he missed the necessary and proper clause. I make no excuse for it. He bombed commerce and necessary and proper. He just did not get that right. The other argument, though, is in Medicaid, which we haven't talked on. But one of the aspects of Obamacare was it expanded Medicaid, which said if you're, I think, 133% over the poverty line, you're not entitled to Medicaid. So it expanded who could get it. The government had a tough position because very early on, there was a letter from HHS to Arizona which said, if you don't participate in this Obamacare expansion, you lose all of your Medicaid funding. Basically, we'll take away all of your funding. This letter was cited once in a footnote in the Florida brief, and it never mentioned ever again. I went through everything. Until the Supreme Court. where Paul Clement mentioned in passing, because he knows everything, the guy knows the brief's cold. Paul Clement mentioned in passing, but we have this Arizona letter, which says if you opt out of Obamacare, you lose everything. The Solicitor General knew that was coming. He wanted to tell the court, listen, we're not going to take away their money, but he couldn't. He couldn't make that representation because Sebelius wouldn't let him. In fact, there was one point where Justice Breyer was getting irritated. He said, what, is this above your pay grade? You can't tell us? He's like, nope, can't say it. So this is a tough spot for the SG to be in. He can't always make the winning argument. He has to be very concise and precise with what he says. And there's certain things you tee up in the briefs that you work on in oral argument. So if I had to give him a grade, Professor, right? On taxing power, I give him an A- because he figured out a way to do it. Right? On the Commerce Clause, I'll give him a D. He made a wrong calculation. He just made it wrong. And the Medicaid, I'll give maybe a B- because he did the best he could with what he had. And they ruled against him. There was actually one funny point where a government lawyer said, they were sitting there in the courtroom, and then when Robert said the Medicaid part, was like, oh my God, we just lost Medicaid. Because no one was expecting to lose that issue. They thought they had that one cold, because the court had never before ruled that spending clause violation happened. So that's my Verrilli report card. But he is an alum of your school. He did not deserve the bum rap he got. In fact, coming into this book, I thought he did terrible. And then only after researching this for a while, I was like, wait a minute. That was intentional. And then I talked to some government lawyers, like, oh, yeah, no, that it confirmed my suspicions.
Yeah, I mean, it's an interesting story of kind of constraint and creativity for government lawyers. The book really highlights how constrained a legal actor the Solicitor General is. There are a lot of limiting principles that might have served well for this case, like that might have handcuffed the government going forward as to Commerce Clause authority generally. And then there's the anecdote you raised about Medicare expansion. But at the same time, Verrilli looks pretty creative in his use of New York versus United States, the way he mined an obscure part of that opinion for its tax power significance. So both sides were very legally creative. Randy Barnett and colleagues are minting a new activity-inactivity distinction, which seems to have 5 votes. The government is explaining why something not called a tax is a tax. For constitutional purposes, though not for Anti-Injunction Act purposes. So let me just ask one last question before opening it up. So now you've alluded to several, I think many of the major pieces of the decision. What do you think will be, on the substance, the most significant part? Is it the constraining of Commerce Clause authority and Necessary and Proper Clause authority? Is it the kind of revival of the tax power as a font of congressional power? Is it toughening up conditional spending limits? How big a deal is this doctrinally?
So doctrinally, I'm not convinced it's that big of a deal because it was a very particular law that had all these really, egregious factors found by the court. I think meta, right? What does this case represent? The Roberts Court will continue the federalism revolution. After Gonzales v. Raich, which was 2003, that was the medicinal marijuana case. It wasn't clear if the court was willing to keep pushing back on what Congress can do. But this just showed that the Roberts Court would police that line. And I think where it happens is a law that's never passed. That is, if someone has an idea of some sort of big law that's expansive to pass, they might second guess and say, nah, maybe I won't do this. Maybe we'll think of something else, think of another basis or another way of going about it. As for the Commerce Clause, this really is only activity-inactivity. It's hard to see any other law that forces people to do stuff. As a political constraint, the broccoli argument is just waiting. So the second anyone tries passing a law, they'll say, what about broccoli? Taxing power, what's interesting is the Treasury Department hated the government's argument. In fact, the Treasury Department lobbied heavily against Verrilli. Why? Because they liked the Tax and Injunction Act. What Verrilli's argument did was they basically waived a huge tool the IRS implements to prevent tax lawsuits. And in their district court briefings since that, they've been backing away from it. In fact, the Treasury Department hated it so much that 2 retired IRS commissioners hired private amicus to file a brief with the Supreme Court saying, no, the Solicitor General is wrong. The government can't do this. So there was actually dissent within Treasury that was very pronounced. As far as Medicaid goes, as we all know now, certain states are in, certain states are out. Once a state chooses to opt in, they're in forever. My new home state of Texas will be the last one in. They'll be Sancta Alamo if Governor Greg Abbott saying never. But eventually all the states will have to opt in because it's going to be too expensive not to. What this means for future congressional spending grants, we now know what coercion means. There was this great image from the arguments of Chief Justice Roberts, who's a Dirty Harry image, saying, Go ahead, make my day. If you don't take my money, I'll take it all away. Or Justice Scalia's image was guy walks up to you, mugs you, says, your money or your life. What's taking so long? Your money or your life? I'm thinking about it, right? It's not really a choice. It's a false choice. And to the extent that this false choice is seen, you might see the court step in again. Questions and answers?
All right, there's lots more to talk about, but let's get everyone involved. So,
Please,
raise your hand.
questions?
I guess I'll start. You give a lot of credit to Verrilli for the tax argument, and I just wonder if the leagues are to believe that the chief was sort of looking for a way not to strike down the law, then in some sense, giving him the tax argument, let him say that the Congress doesn't have the power under the Commerce Clause. If he wouldn't have had that, he might have had to say the Congress does have the power under the Commerce Clause. So in some ways, he might have been giving him an out, sort of stick with his conservative, bona fides on the Commerce Clause and find his.
I'll tell you, the Solicitor General was very clear when I talked to government lawyers that he thought Roberts was a fifth vote, not Kennedy. He thought that Roberts' commitment to the democratic process and respect for the separate branches would power him over. Justice Kennedy has shown no qualms that strike down major laws. Roberts was an unknown. Well, not so much unknown, but even if you remember in Citizens United, he had this concurring opinion saying, well, we're striking it down, but here's some other factors to consider. So I think Roberts has a strong commitment to the separation of powers. As for could Roberts have upheld the law without Verrilli's argument? Probably. I'm sure he has really smart law clerks. I'm sure you're all vying for it right now to try and think of ways to do it. But this was a very elegant way of doing it, where he wouldn't have to touch a commerce power, he wouldn't have to mess up other spending doctrine. That one saving construction really put the law on solid footing. Oh, come on, you guys are Columbia. NYU asked more questions. I'm about to tell Bob Morse. Yes, sir.
Do you mind, clarifying how the Supreme Court was able to reconcile the idea that it was not a tax according to the Anti-Injunction Act, but it was a tax according to the tax and how they were able to get around that?
Okay. So the question was, how can the court say that it is a tax for purposes of the that's not a tax for purposes of the Anti-Injunction Act, but it is a tax for purposes of the Commerce Clause? Well, they never actually said it was a tax. They said it should be construed as a tax. That's why it's called a saving construction. Even though it's not a tax, Robert said it doesn't look like a tax, to save its constitutionality, we'll pretend it's a tax. It's like a make-believe sound, like Mr. Rogers. We'll pretend it's a tax, and that will save it. That was from the O'Connor opinion in New York. The court had never done that before. President Pozen might have some other thoughts. It had never been done before. I can't imagine it will be done since. You can be sure that going forward, if you're drafting a statute, you're going to try to make it clear whether something is or is not a tax. But that does have one salutary benefit. Hidden taxes can't be slid through now. A lot of people viewed the Obamacare law as a tax from the get-go, and the administration didn't want to take the political hit of passing a tax. Now they're going to notice that they can no longer do that.
I think just to add on that, the court reasoned that for purposes of the Anti-Injunction Act, labels matter. What Congress said, that was just statutory interpretation, and which we're just going to stick with what Congress wrote into the statute, that in that case not a tax. But for constitutional purposes, we can't just stick to the statute. We have to look more holistically at how this thing functions, and it functions like a tax. And because of our constitutional duty to try to save statutes when possible, that's how we'll construe it, as Professor Blackman said. So the main way in which the Supreme Court got around that seeming doublespeak is the difference between interpreting statutes versus interpreting constitutional provisions.
The government said it was, quote, a problem of nomenclature. That's what the government decided internally. They didn't think it was a big problem. They thought they could pull it off. That was their strategy. It actually worked. Other questions? Yes, sir, in the back.
How replicable the notion of this, the sort of generation of new Supreme Court doctrine and the inactivity-activity distinction, like how replicable do you think the template is of like the truncated time frame, the initial brainstorming session, like the use of the Heritage Foundation, or was it like, you sort of seem to describe a perfect storm, but do you think that is a model that can be used later?
you know, I think I like that expression, perfect storm. That's why I love the cover with this stormy cloud of the Supreme Court. A lot of things came together at the right place, but I think what was important is you had an institutional framework in there beforehand. Groups like the Federalist Society, Heritage not so much anymore. Since Senator now DeMint has been in charge, it's been kind of taking a different path. But for many years, Heritage and FedSoc have been developing and inculcating thought and processes. You have these meetings, you have Federalist Society groups to come together and talk about things. And when something happens, you can move quick. So think of Bush v. Gore, right? How long did it take Ted Olson to figure out the argument as to why stopping the Florida recount would violate the protection clause? Like a couple days. And within 30-something days, it went to the Supreme Court to rule against it. So when there's an urgency, the Constitution can move fast. When there's not, it takes its time. Let's look at from Romer to Lawrence to Windsor, and whatever comes next. You know, gay equality might take 25 years. Obamacare took a couple months. So I think it's a large matter of expediency. And as he said, there was a machine behind it. There was a lot of money involved here. There was a lot of politics involved here. Mind you, the Republicans lost in 2008, right? The time to have stopped Obamacare would be electing John McCain. Or the time to have repealed Obamacare would be electing Mitt Romney. Neither of those things happened. I hope I don't disappoint anyone in this room by saying that the law will not be repealed. It's not going to be defunded. It will be implemented. It will be very rocky and bumpy. We're going to be living with the thing probably for the rest of our lives. And eventually every state will opt in except for Texas because Greg Act did the Alamo thing. Never for my cold dead hands.
You know, it is fascinating as a professor too. There is no shortage of kind of competing reconceptualizations of various constitutional provisions floating out there in the scholarship. But to see one seized on by litigators and then a political party and then a whole half the country, it seemed, and almost swing the court in the span of a few years was amazing. I would say the leading reconceptualization of the Commerce Clause power on the political left, spearheaded in large part by Professor Jack Balkin, who's already come up, is that he says he's found a lot of originalist evidence that at the founding the term commerce meant something more like all intercourse, maybe barring one type of intercourse, but all social and political intercourse, even well beyond trade or manufacture and commodities. And if that's right, then we shouldn't be worrying so much about whether all these things are within the Commerce Clause line, because it was always meant to be an extremely capacious concept. So that hasn't really gotten legs right now. That would probably terrify a number of justices. But maybe one day we'll find its movement and its justices too.
Originalism was actually very lacking in NFIB. There was,
yes,
other than a couple of amicus briefs, there was not much discussion what the original meaning of commerce was. They didn't even bother. By the way, Randy Burnett has a somewhat critical review of Balkin's intercourse piece. He screws with it, I suppose. Any other questions?
Yeah, we've got about maybe, I think, 8 minutes.
And I'll be signing books if anyone would like. I'd be happy to sign. I know students are tight for money, and if you don't want to sign a book, I have other book plates and things you can sign. You can order on Amazon later, which I'm totally okay with you doing. Tell Barnes & Noble that. Any other questions? Yes, sir, in the back.
Could you talk a little bit about what sounds like some pretty incredible inside access you got in writing this book, and sort of how you manage that?
So I'm sitting next to one of the national experts in the idea of government leaks. Yeah, he specializes in leaks from within the government. So I won't clarify that.
Not as a protagonist.
No. So what's interesting about government leaks, and this is nothing with Obamacare, is that people want their side of the story to be told, right? If you're a professor or you're a litigator, you're perfectly free to write an op-ed or an article discussing what your role is, right? But if you're in the government, you got to stay quiet. There's a reason why government people talk to lawyers, and talk to journalists. I mean, sometimes it's noted, right? They want to release things and blow the whistle. Other times, they want to make sure that their side of the story is told. And that presents challenges, because then you have to say, okay, is he telling me this because it happened, or is he telling me this because he wants me to know? The other related issue is, how do I know what he's telling me actually happened? If I publish something under a person's name, someone can say, no, he didn't say that, here's what happened. If I say a DOJ lawyer. So in writing this book, I was very careful to at least get two people to tell me the same thing. A couple times I couldn't, and I would hedge in the book, but I tried to at least get someone to confirm what I heard elsewhere before I ran with it. It's not always possible, and I'm positive in this book there might be a couple things I said that when the history gets written in 50 years and all the justices' papers are released and the SG papers are released, I might be wrong, and I fully accept that. But my goal here was to try to be as objective as possible and tell the story of what happened. It's an important story to be told because constitutional law is what defines so much of what we do. You have Congress, after an election, passes massive law, and 9 people wearing robes came this close to saying, nuh-uh, it's all gone. And the process that we got there has never happened before. It was unprecedented. And I think by studying this process, we can have a better sense if we see it again. I don't know what the next constitutional black swan will be. I don't know what it will be. No one knows what it will be. I mean, when George Bush was elected in 2000, could anyone have said in 2 years we'll be defending detaining Guantanamo, inmates at Guantanamo? Of course not. But lawyers developed these arguments about habeas corpus and rereading, Ex parte Milligan, all these cases which we've buried for 50 years. When George Bush had the election, Bush v. Gore, who could even think of that? No one thought of that. When we had this Obamacare law was passed, no one took this challenge seriously. People were saying this will be 9-zip. I personally said this will never get to the Supreme Court, but it happened. So you're all smart people. When you see this stuff happening, you've got to realize you're living through history, and maybe we can do it better the next time. And maybe cite some of other scholarship that wasn't in white papers by the Heritage Foundation.
Yeah, so I mean, some of the material on Barnett in the book is particularly rich, I thought. The sense in which he was this constitutional norm entrepreneur is really, really striking. On your question, I thought that the reporting was very diligent and careful and impressive. I did note as a reader that you were coy at a number of places about who was speaking. I thought I heard Verrilli himself speaking a number of points, but it was not clearly sourced. I assume this was all intentional, but that I think was presumably the price Professor Blackman had to pay to get access. So maybe one or at most 2 more questions to close this out.
While you think of a question, oh yes, go ahead.
You said like Barnett's argument came out of left field. Is that
Right field, actually.
Okay. It's because mainstream academics are so far removed from the assumptions of the conservative movement, or really Barnett had a brainstorm.
So this wasn't actually Randy's idea. I love Randy, but he doesn't get all the credit. There was actually, I swear to you, a law review article in the Case Western Law Review by a guy named Nathaniel Stewart. It was written after Gonzales v. Raich. And the title of the article was something like class of activities. His argument, this was like a 2004 law review article, Case Western Law Review, was that after Raich, government can regulate activities, but reading Scalia's concurrence very carefully, they can't regulate inactivity, or a class of activities. And their argument didn't really have any merit because no one was trying. But shortly after the Obamacare law started getting around, Nate Stewart knew someone at Heritage, and knew Todd Gaziano, and then Todd said, hey Randy, I got this guy who can write a paper with you, his name's Nate, let's write a paper together. So that white paper by Randy, and this is in the book, Randy didn't write most of it. He was very good at editing it and massaging it and finessing it and putting a very strong point on it. But he didn't invent the unprecedented idea. It came from a random law review article. And at just the right moment, it seized the moment. And it got serious traction. Because I'm not kidding you, within moments of the report being released at Heritage, they were briefing Senate staffers. And like the next day, Orrin Hatch read into the record. I don't know any law review article that went from like publication to congressional record in a few hours. It's remarkable how much effort was. A side note on Orrin Hatch, back in 1994, he sponsored a bill that would have had an individual mandate. It's called the HART Act. It was in opposition to Hillary Care. He actually wanted people to have a mandate back in the 90s, but then he changed his position in 2009. Most everyone else in the Republican Party.
I would just add that my sense is that there was this kind of inchoate feeling broadly held among many millions of Americans that there was something potentially novel and intrusive and worrisome about the mandate, but there wasn't an obvious legal vocabulary in which to articulate that. So whether he was seizing on a previously written law review article or adding new insights himself, just the moment when the activity-inactivity distinction arrived as the way to kind of frame in a constitutional sense what was troubling about this law was an important breakthrough, it seemed. Another reason why so many law professors might not have picked up on the seriousness of the challenge, other than misreading politics, other than academia potentially slanting left or what have you, is one example one heard a lot early in the discussions about the mandate was quarantine, things like quarantine. There's a lot of Supreme Court precedent saying that the federal government has power to quarantine individuals who are sick as necessary to protect against spread of infectious disease. That kind of seems like regulation of inactivity. You know, the person's just sitting there sick, and next thing, you know, they're thrown into a detention facility. So won't the activity distinction lead to a place where quarantine can't be done? That can't be right, because quarantine needs to be done in some cases. So I think that was a conceptual obstacle a lot of people had to thinking the distinction might have bite as well. There's a very interesting student note coming out in the Columbia Law Review by Arjun Jaikumar, one of your classmates who probes that issue. But some reflection. So do you want to close out with any last thoughts before everyone has to?
Sure. Yeah, sure. So thank you very much, David and Federalist for hosting me. One thought to take away that might be helpful for all of you, because you will all be the leaders of a legal profession, is to think of how you can find these moments. It's not often that these moments occur, but you kind of have to be at the right place at the right time and seize it. Barnett was, and the work he had done before that got to that point, and he was able to utilize his capital and reputation to kind of build on this. And as you all think of your careers and how to aspire to kind of high positions, place yourselves in the right position, get to know the right people, have the ability and the flexibility to kind of challenge things, look at things differently, reconceptualize things, and you never know. I don't think this will ever happen again. This is probably a one-off, but there might be circumstances in smaller contexts where you can do similar great things. Thank you very much.
Thanks.
Thank everyone for coming. Thank our friends Blackman and David Pozen. Once again, there are books for sale outside. Thanks a lot.
It's supposed to be